Article 155 of the 1980 Constitution, with the 1996 reforms, states no person shall be qualified for election as a member of the National Assembly who is, by virtue of his own act, under any acknowledgement of allegiances, obedience, or adherence to a foreign power or state. Further, Article 156(1) of the Constitution states that a person shall vacate his seat in the National Assembly if he ceases to be a citizen of Guyana. Leader of the National Independent Party, Sapphier Hussein Subadar, says the issue of some members of parliament from both sides of the House holding citizenship in Guyana and another country simultaneously constitutes an ongoing breach of the Constitution. A breach which he said is acknowledged but has still not been addressed or corrected.
I have received information and verily believe that there are persons even in the present government who has violated that article. And there are persons in 3 other parties.
The argument being presented is that the constitutional provisions are intended to ensure that legislators are loyal solely to the country of their birth. Mr. Hussein highlighted that the 3 main political parties are still acting in contradiction with the subject articles of the Constitution. He says this must be changed.
The time has come to restore constitutionality and the rule of law in this country.
A similar situation arose in Jamaica a few years back, where politician Mr. Darrell Vaz gave up his naturalized U.S. citizenship in order to continue being active in the Jamaican political arena. There is the feeling that those with dual citizenship cannot serve 2 masters, since a legislator should be fully committed to the service of one country. Mr. Hussein said this is something that he will personally address.
I will get all the evidence and I will file a motion that no person who is disqualified under Article 155A1 can contest the election.
Mr. Hussein's concerns were shared by other prominent Guyanese over the years. The U.S. and Canadian embassies have both confirmed that it is not a necessity for a Guyanese who would have attained U.S. or Canadian citizenship to renounce that of their birth country. Both sides of the House have expressed concern.
Good evening and welcome to Plain Talk. There you were saying Mr. Sapphier Hussein, an attorney at law and political leader, speaking of Article 155, which, as you know, prevents persons with dual passports or dual citizenship from being elected to Guyana's National Assembly. Well, that problem has been going on for years, for decades in fact. Members of all political parties, the PPP, the PNCR, the AFC, the WPA, they've all been guilty of violation of the Constitution of Guyana. Mr. Sapphier Hussein is my guest this evening. As I said, he's an attorney at law and a political leader. And Mr. Hussein, maybe I can start by asking you this question. Is there a place for small political parties? As we saw on the screen a moment ago, you're the leader of the National Independent Party. Is there a place for small political parties?
Well, I think this is the ideal time for other parties to evolve into something significant, because at this stage, the 2 political parties have proved over 50 years that they're incapable of really bring this country to a new standard or a new Guyana or something of some significance. Guyana has been reduced. It's demoralized. It is underdeveloped, I think, by these 2 parties for the over 50 years. Not only the legality in Parliament, they were never a legal government.
When you say they were never a legal government, I mean, for a lawyer to say that, that's a pretty strong statement. Are you saying the government of the PNCR prior to 1992, the government of Chedi Jagan in 1992, that those governments were not legal?
No, Article 155 says that you can have dual citizenship and then you a member of parliament.
That addresses individual members. We're talking about governments now.
No, but how could the government be legal? Because their party list was not a proper list before the election commission.
Yes.
You have to name X number of persons.
So,
and the candidates they named were not qualified, so they never present a proper list for election.
Yes,
so
but
they could not have been elected.
No. All right. Let's calm down. It's we're only just beginning. Now, the law does provide the mechanism where someone is not properly elected, isn't it?
Yeah, there
The
is.
Representation of the People's Act.
Yes.
And it says that if a challenge has to come against any elected person, that challenge must be brought within 28 days. It says that, doesn't it?
Well, that is in the electoral the act in itself in
Yes.
relation to.
So the law says that.
But that's not the problem here.
I mean, that's not the problem.
No, this is a document all of them have to swear. This is
No.
In fact,
Please.
This is a copy of Charandas document.
Mr. Sapphier Hussein,
No,
we're
listen.
trying to bring some order to this program.
Yes, well.
Okay. We're talking, you said the governments were illegal.
Right.
I am pointing out to you, there is a mechanism to bring a challenge against an elected member of the National Assembly. Isn't there?
But that was the abuse of the whole thing by the persons who are elected. No, the list, in fact, itself, we can look back retroactively now and see that all the lists were illegal at the time of the election.
But isn't there a legal process? And I'm trying to get you to answer that simple question. Is there not a legal process for challenging the legality?
All right, if you
And the Chief Justice was quite categorical about it in her ruling in the cases.
I in the same program some years ago I told you the same thing, that it is the election petition inhibition by that election petition that the illegality concerns the government, because the election petition is the way to challenge the member of parliament.
And so, if you don't challenge it, the persons they remain properly in the National Assembly.
They are there in the assembly, but they are there not. The legality is not because it has not been challenged. It is still remains illegal. But if you look at it in juridical process, you will say, well, look, because I'm assisting you here now. Because
I don't need assistance.
Because it was not set aside, it's legal. It was not. Look at it. It was immoral as well.
Well, the law
right?
is not so much
There's
about
some morality in law. Read read Granville Williams.
Mr. Hussein, don't let's go all over the place.
All right, but
The law is about
get to this
the law.
particular point. Each person has to.
No, we can't be reading throughout the program.
No, each person has to.
Just tell me the
You
summary.
have to swear a statutory declaration.
We know that. But aren't we going over the same
this
thing?
Statutory declaration say that I make this declaration consciously.
We
being
know
going
that.
through. And not only say that they are aware of 53 and 155 and
We
they
know
have complied
that.
with.
That's what we said. That's what makes it illegal.
Right, it's illegal. No, but that's not what the point I'm getting
So
at.
what's the point you're getting at?
I'm getting at that all these persons have to now be charged. Look,
If
this
you
is-
want,
this
who
is-
should charge him?
Well, DPP should do that, or I can do that in a private criminal.
Isn't there a mechanism for those persons who have violated 155
Yes.
to pay a fine on an action brought by the Attorney General?
No,
Isn't that what the
that's not
Constitution
so.
says?
It says, the Act says that here, under Section 327 of the Criminal Offences Act.
I don't want to get involved in law with you. You know.
No, the criminal.
That is not the
no,
applicable law, mister.
The Criminal Offences Act
I
says
know what you're going to say.
everyone who being required or authorized by law to make any statement upon oath or in any form permitted to be substituted for an oath thereupon makes a statement which will amount to perjury if in a judicial proceeding shall in any case not expressly provide any written law for the time being, be guilty of a misdemeanor and liable to imprisonment for 2 years.
And are you,
Article Section 327 of the Criminal Law Offences Act.
are you aware that there's another legislation you just read
Yes.
that it
Criminal Law
says
Offences Act.
in any case not expressly
Expressly
provided
provided.
for by any
Other-
written law?
Yes.
Do you know there's another written law that applies to such a situation?
It does not apply to criminal offences.
No,
It applies in case there is some other thing.
No,
of
no,
the
but
member
here,
of Parliament.
listen, I can't have you reading out all these documents you brought, you know. All I'm saying, this, and I'm not defending these persons.
Well, they will defend it because we'll file private criminal.
Well, you file, and you should have filed by now. What they've done, they've made a statutory declaration under the Representation of the People's Act, and the declaration itself is made under another law that says what the penalty is, and it's not 327. It's not 327. It's the statutory declaration act, and it says it's 1 year. But I agree with you. Let's move on. Let's move on,
Yes.
because the court has already ruled on this matter.
And the court has ruled that they were illegal.
Yes, no
Right.
question about it.
So the inhibitions by the election petitions gone overboard because the judges now have seen the illegality, and they have used the inherent jurisdiction and said, look, we have to stop this illegality.
Well, that's not what the Chief Justice said. Anyway, I was asking you, we started by talking and we're trying to get some order.
Yeah.
Is there a place for small parties in Guyana politics?
Well, because at that stage, the failure of the two parties over 50 years,
Yes.
persons in the man in the street have now recognized that there is a need for parties who are independent of these two major parties.
Mm-hmm.
And that will probably be the only solution to Guyana's problem, or else what is happening? The two parties are always in conflict, and more of the legislative and time is spent arguing as who is more dishonest and whatnot, without addressing the issues and the need for the man in the street.
What would you say? Okay, let me take that as given.
Right.
Just for argument's sake, let's say that is true. What are the needs of the man in the street or the woman in the street?
Yeah, the man in
And by that expression, you mean the ordinary working class,
look at Parliament,
single mothers, and so.
Parliament, the location of Parliament, right? And I traveling in a taxi recently when they had Parliament, and all the people have to line up with the cars and so on, and they're cussing up Parliament, and Parliament is talking for we are in the interest of the man in the street, and the Parliament building should be held somewhere else. So the Parliament should be held somewhere else. You have people lining up in the streets, medical. If a person's sick, you can't reach the doctor, you can't reach the dentist. People with pregnant women and suffer, and have them in this. This is elementary, but this is probably an elementary part of the thing. But it shows the way the politicians in Parliament operate. They do not aware
Insensitive.
of course.
Well, but tell me something. How long since your party was in existence?
Yeah,
the
we
National
started
Independence.
1992. I was with another party, Bobby Gangadin and them, and from 1997 my party was formed and functioned. And I fight all these issues. In 1997, I talked about this.
Yes, you follow those issues,
Right.
but you
Janet Jagan, I said she could not have been a member,
All right,
president of
okay.
Guyana. I argued that year.
As I said, I'm still trying to get some order. We're talking about small parties. You're saying that the two major parties have
Have
acted outside of the interest in disregard of the interests of the man and woman in the street. Yet, when you go to elections, what you calling the man and woman in the they vote for these parties.
Electors because
how do you explain that?
Because of an ethnic culture, political culture.
Yeah, but
right. So how do we get out of this? People start to reasoning about policies and so on, and then.
But are you saying that the average voter in Guyana is irrational? Is that what you're saying?
It is not. The voting, the electors do not vote on the basis of policies and so forth. They vote. 90% of the voters in Guyana is based on ethnic policies. Conditions.
Why is it? You said that since 1997, your party has been in existence.
And fighting the election too.
And fighting elections.
Yeah.
Have you ever topped in any elections 2,000 votes?
No, I never reached 2,000 votes, but I've had votes and I've made an impact. In 1992, for instance, when I had discussed Article 162 of the Constitution, which made a very big impact that time, because Article 162 is saying that the election commission can postpone an election
under specified circumstances. Let's be very careful.
Right. Yeah.
And you can only postpone an election that has been called.
Exactly.
You can't postpone something
after the election has been called, though. The president cannot then postpone the election.
Who postpones it?
The election commission has to now postpone the election because of.
Maybe you should say what 162 says.
Well, it says because of if there is like grievances or
162 says, and it's good that you've raised it.
It will come out in the same case.
Notwithstanding anything to the contrary in the Constitution, if the Elections Commission is satisfied that the holding of an election pursuant of the provisional part on the day appointed, therefore, would be attended either generally or in the party by danger or serious harm, it may, after consultation with the Prime Minister and the leader of the opposition, it is not the President, as you correctly said that.
I said that.
Yet the President keeps inserting himself in all electoral matters.
Yeah, I said this on Channel 6 and Sharma, and the other guys laughed at me, said, how can you talk about the Prime Minister? But that's what the article says. Jaipal is an expert in Constitution, He needs to talk a lot about Constitution.
Who is this?
Mr. Young Sharma, Minister of Finance.
He's an expert.
No, he says that he knows a lot about Constitution. So. All right, so this here is the Prime Minister.
My thing is,
all right.
We are saying that these persons are irrational, and therefore they will continue to vote not for the small parties.
Well, you see, the serious consideration is, I think there is a question of dominance of one sector of population, and both sides are looking that each may dominate the other. Neither of the two of them have ever been able to openly or expressly or to the satisfaction of the population shown that they are capable of governing in the interests of the entire nation.
Mm-hmm.
It is all superficial talk on both sides, and that is the problem the country is facing.
But so why do you think? You have been around, you've been writing, you've been speaking, you put yourselves up for elections on a number of occasions. Why do you think you've been rejected at the polls?
Well, my experience is that during the campaign you have a lot of supporters, but just it comes like the day of it near to election, those persons who profess to support you either go one party or the other.
Why do you think they do that?
I think it's the same issue of ethnic dominance and cultural, historical, political culture and so forth. But if you look at it I see over the Independence Week they did a lot of work on the history and the immigrants, the indenture system and the slavery system and so on. Probably out of the evolution of that history, like 1920 was the indenture system came to an end. That would be 100 years ago.
Mm-hmm.
And 1838, the slavery system. So from after the 1838 to 1920, there seem to have grown some kind of conflict between the people at that time, and it is the descendants. It seemed to continue. However, the modern Guyanese should now recognize and well, look, we are away from that history, and we are now Guyanese, here, born and grow here in this South American country, and we should have an individual and unique situation for us to develop in cooperation and interest of each other.
But isn't it true that we hear that all the time? That look,
yeah, but that is what we have to.
We are interdependent.
Right.
We are here on the same land. We've all helped to build it. Our future lies here. That's just platitudes. That's
Yeah.
banality. It
Yeah.
doesn't happen in practice.
Yeah, but it is very difficult to pinpoint the cause, because when you go to school, you're saying my Guyana, El Dorado, the best of all the world to me, and that's and so on, my native land, and persons of all ethnic persons go there, but after school and so on. And election time only, I think, it's only election
That's
time.
not true. That's not
is
true.
Basically
It in
dominant,
fact is there, but that's really the cause of the
Yeah.
separation. But
Yeah.
it's not true that it's only happens then.
It become more acute and so on.
Yes,
at
it becomes more
election time.
But my thing is this. My thing is this, and Mr. Hussein, I congratulate you for trying. You've been out there.
I've made an impact, although I've not been in Parliament. I was telling you Article 162. When Do Not Sing said that you have to pay $1 million in order to fight the election, I brought a motion. Justice Barnard was the judge, and quashed that. So you don't have to pay X amount of money in order to contest the election, because you would have been
But
discriminatory.
it's part of the problem that lots of the small parties, like yourself, and we talk plainly, it's a one-man show. You don't have a political party.
No, I have supporters all over the country. I have lots of people
No,
all
but
about.
where is? I keep asking this, and I ask this of lots of other persons. Where are the members of your executive?
Yeah, well, we do not operate in. In fact, that I think might be a problem, because the way those two parties operate, they tend to control. They use local government and all this kind of system to help to control the people, and the so-called supporters. But this is just because the way the government is organized and so forth help them to maintain this kind of conflict.
But why don't you do exactly what they do? Work through the local government bodies,
yeah.
Work through trade unions, work closely with the rest of society, get yourself in the media, get yourself out there, do things for communities, and people will regard you as a genuine leader.
Yes, the media also is discriminatory. The media, for instance, I maybe unless I set up my own independent newspapers, because the newspaper don't publish things favorable to yourself. If something that happened, if you lose a case, they might publish it. But when you win several cases, they wouldn't publish it.
But
probably.
that's not the role of the media to promote you winning or losing a case.
It's not promoting, but this is news which should be published, and so that
But look,
objectively.
Cases are won and lost
No,
on a daily basis in the
no.
courts.
And press reports. Look, my recent press release, I sent it to Culture News and so on, and they have not published it. Well, this this would be a this would be a very news to Guyana.
As I said, we want to keep this thing a little
Yeah, but yet
structured.
still we get the facts.
No,
in.
no. Can I
No.
please?
Yes.
Can I please? Why do you think Kaicho News? Do you have the same experience with Starbuck News?
The Starbuck News, I think, is worse. They hardly ever publish anything about me.
And why do you think that is so? Do you think they're discriminating against you?
I think these press, they have been discriminating. I had sued Chronicle some years ago.
But that's not Starbuck News.
That's a long time.
But that's not Starbuck News.
Not Starbuck News. But Starbuck News had some problem in not publishing my thing. My
No,
information.
but so
But this information.
Can I,
you
again,
want
I
to
come on. No,
release
not
this
yet.
one?
We'll leave it.
Yeah.
Can we get to this, because you're making a fairly serious statement about the media, that they're shutting you out. You're a
Yes,
political
exactly.
leader.
Yes.
They're shutting you out.
Or maybe also financing.
Access to information.
Yes, you have to finance some sort of programs and so on and so forth too. That also might be a limitation on our side. But they have a responsibility in public interest to publish information.
But they publish information if they think that information is in the public interest.
Right.
So,
but sometimes it is in public interest and they don't publish it.
No, but it might be it's a judgment call of the editor. The editor may think that, look, this thing has no public value, and I don't carry it.
All right. Look, I wrote a letter to the chairman of GCOM.
No.
And I sent it to the press had it.
Uh-huh.
And I said, chairman of, and this dated 26th of February. And said,
Of this year?
Yes. The present court proceedings in relation to the no confidence motion will affect the general election which is imminent. My party recommends and support that the Guyana Elections Commission, which is an organization under the Constitution Article 161, makes an application to be joined as an interested party in the proceedings in respect to action 2019, 22, and so on. That is since February. I tell the election commission to join it.
No.
This thing was never published. What do you think they do? They write a letter disregarding it. Listen. Now when they go to the ICJ, into CCJ, the first thing they did is join the election commission.
No, but
the thing is that some of the things I have done and so on is outstanding and above what the average party even think about and so forth, right? Like this, for instance. All of them get embarrassed, all them lawyers, everybody, including probably you. The CCJ
when you say they got embarrassed, what do you mean?
The CCJ said that although nobody make an application for the election commission to be joined, we will join them.
Mr.
Sapphier,
Sapphier Hussein,
Didn't say
you're
that?
not being honest.
What he said?
Because it was one of my lawyers that brought an application for them to be joined. So don't you say that, please.
I listen,
No.
I listen and
the
court says
you deserve credit.
You
deserve credit for having raised it, but don't say you were the only person. That would not be true.
All right, that's one.
No, let me ask you this.
But you know why I asked that to be done? Because in Manitoba, in Canada, in Manitoba, when they had a kind of constitutional crisis. That is what the judges do. They bring all the parties to make submission, and then pursuant to the rule of law, they ratify or legalize that which is done.
My viewers, the viewers of this program are not all lawyers. So when you start talking about Manitoba, I think you owe it.
I hope you must submit that to the CCJ.
No. I'm saying we talking this program now. We're not talking CCJ. That was a case in Canada that had to do with legislation that was brought and that was written in English only.
Yes, language. Yes.
And under the Canadian Constitution, legislation has to be bilingual.
Language, right.
And so that's the. I just want to put it in context. Let me ask you this: why do you think the CCJ has been taking so damn long to come out with their decision, having criticized the domestic courts?
Well, it's a very difficult decision for them to make, and that is why you should get to my most recent. My most
No,
recent
Miss, please, we're talking
Yes.
about the CCJ. We're not talking, and we are talking about you as well.
Yeah.
But I'm asking you, why do you think, and is it acceptable?
But they said 3 months or
That-
something.
Is it acceptable that they should be spending this amount of time to decide what were probably 5 or 6 issues on which they had voluminous submissions? They had several weeks. It's, as I said, it's now 3 weeks since the case was closed. They had submissions at least 3 weeks over a period of close to 3 weeks before.
Yes.
Yet, incredibly, these people, as though they don't understand what management is all about, are busy listening to other cases
Oh, I see. Yeah.
instead of saying, look, we've got a serious constitutional crisis in Guyana.
Yes.
We have a set of major cases. There are about 6 issues. There were 5 judges who listened to the case. They could have identified the 5 or 6 issues and allocate them
Yes.
according to the judges and say, look, you write on this, you write on this, and then we will conference and come to a decision. Why do you think they're taking this long?
I think they want to give a very meticulous decision. That's one, and they have a responsibility as a CCG to make to give a decision for really have credibility.
You mean they
And,
can do a decision in an efficient way?
No, well, it will take time because they are not organized. Like for instance, Court of Appeal in I was associated in a case in Ontario Court of Appeal once.
Mr.
No, but
listen,
how
this
they
is
operate.
one miss. No,
This
but
is how the judges
Yes.
operate there. Each of them has a point to examine.
that's what I just said.
Exactly. That's why I'm saying.
But that's common sense.
That's how the Court of Appeal in Canada operates.
That's common
So
sense.
when you go
Are
up
you
there-
suggesting that the
Yeah.
judges in the Caribbean
I
Court
don't know if they are organized
don't
that
have common
way.
sense?
No. When you go up there, each of them asking you question on a direct point which they have researched.
No, I
and
understand what you're
mastered.
saying.
You're right.
Isn't that common sense? Shouldn't these people
They should
be-
have done that as well.
should they be hearing other cases at this
No,
stage?
At this stage, they should probably put it down in the
You know,
as a state of emergency
now,
kind of existing.
they
a
have this
situation.
Caribbean Court of Justice has come in for some very serious flack
Yes.
from the public, and they're not helping themselves.
Yeah, that's
Now,
right.
How would you rate their performance in this case, Mr. Hussein?
Well, I don't want them to hold me in contempt, you know. So
You know what? You know,
I-
Article 146 gives you freedom of speech.
Yeah, in fact, I was just reading that in a case in Canada about freedom of speech in relation to matters like that.
Yes.
I think I have it here too. That you have a right of expression and so on. and
Of
so
course, you
forth.
have a right of expression.
Yeah,
You don't
freedom
need.
of
You don't need.
expression.
You don't
No,
need
but they-
Canada to tell you
they
that.
meticulously deal with it in that.
No,
case,
but the
you
point
know.
I'm making.
But this case here.
No.
What had
Mr.
happened to-
Mr. Hussein,
You
I-
probably saw it, Patrick
no,
Manning.
No.
This
I
case
know.
was decided in Trinidad
Yeah.
Court of Appeal.
But we're talking.
With a similar crisis.
But do you think the Caribbean Court of Justice truly appreciated the gravity of the matter that confronted them?
Well, from the beginning, it appears as if they did that. From they expressed how urgently they will do this matter and so on and so
Yes.
forth. But as the matter progressed, they seem to be now reversed into a position of, I think, abundant caution, and that is why the delay. They realize in fact, what they realize is the gravity of the matter,
So
not the urgency of the matter.
they're putting
Yeah.
caution
Exactly.
before
Urgency.
not so much urgency, before importance, because this matter. Look, Mr. Hussein, they had, what was it, five judges or six judges? Here we are.
Well, you were there.
Yes, I think it was five. Each of them, this is one of the least busy courts in the world,
Yes.
the Caribbean Court of
Yes.
Justice. In terms of an original jurisdiction, the revised Treaty of Chaguaramas,
Yes.
they hardly get cases on that. They get an occasional case. In terms of their appellate jurisdiction, they have 4 countries.
Yes.
Guyana being.
I appeared before them in a couple cases,
Yes.
and
So
I got good
they're,
results.
they're
in
not
this,
that overworked, are they?
No, they're not very busy.
And
busy court.
they got some
They're not in.
issues, for example. I don't know how good you were at maths at school. I wasn't
Oh,
very good.
I did 2 years of physics and maths at university.
Okay.
Yes.
Was the majority of 65?
No, you see, that is the problem, right? The problem is, and that's why I can't mention Mr. Sharma, young Sharma. You can't talk as a layman what is the majority of
Well,
65.
I'm asking you a question.
No. This
What is the majority of 65?
No, this is not a mathematical problem.
So what is it?
This is a legal and constitutional matter.
Listen, they got something named common sense, you know.
No, here.
Okay,
No, but as
let
a
me ask you this question.
As a lawyer,
No,
you can't
no,
say
no.
that.
Of-
Here, interpretation.
I can't say.
No,
I am
it's
saying.
It's not common sense.
No,
here.
tell me something. What's the majority of 5?
In a
Answer my question.
In mathematical, what is the majority of 5?
Of 5?
Well, majority of 5. We're not talking case law or interpretation or
You
constitution.
tell me whatever you
We're
want to
talking-
talk. What is the majority
we're
of 5?
talking maths that we have. What we have? 5 pints of milk, and we want to give one person 3 pints, and that's
You
the
want the milk, okay.
right? But we're talking here. You talking here interpretation. Look, I just got a book from England on interpretation.
Sapphier, let me tell you something. You know, you lawyers like to pretend that you have some superior knowledge.
Exactly.
This
Here,
thing
interpretation
is a matter of
no,
English.
Here, no, it's not. Interpretation of constitution. In fact, I don't think you all submit an article which I have on the interpretation of constitution. I don't have the reference here.
Mom, please.
No, listen.
So the
No,
majority of 5 is how much?
No, here what this 99% of Guyana, and including you now, using something called literal interpretation. That is only one method of interpretation, my friend. You know, literal interpretation.
Mr. Mahar,
is only
listen,
one
I didn't
method
come
of
here. I
interpretation.
did not come here to discuss law. We're discussing
You
the
ask
case.
me what is the
No,
majority.
I'm pointing out
right?
to you.
Yes.
The reason I'm pointing out to you.
Yeah.
Look, there are some very straightforward issues.
All right.
It is.
All right,
Hold
so
on. Let me finish,
no,
please.
literal interpretation
Let me finish, please.
can't solve that problem.
Let me
You
finish,
have
please.
literal. You
So-
have to,
so tell me something.
You can go back to the.
Tell me something.
the-
Tell me something. Answer my question straight.
Yes, right.
Did you agree with the Chief Justice's decision that the majority of 65 is 33?
If you are,
Did you or did you not?
I do not agree with her. I think it was per incurium decision. All the
man, forget the Latin, man.
All the authorities were not discussed, and all the proper submissions were not made.
Which authorities were not discussed?
Several authorities. I even have authorities with them.
Oh
Look,
God!
you know judicial.
Why aren't you a judge?
You know,
Why aren't you a judge?
in 1992, Sapphier and some other lawyers had asked me to become a judge. You know,
How's
because
Zephyr can offer you?
no, he was working with the organization and so on.
Which
So,
organization?
I know the Judicial Service Commission and there. And I said, man, look,
No, the point I'm
doing so much good
Sapphier,
practice.
the point
But get the point, let's hear it. You have literal interpretation. And all we all are talking is literal interpretation of the majority.
No.
You know what judicial activism is now today in the world? Judicial
Don't bring
activism.
that bull to me, please.
Yeah,
Because judicial activism
Uh,
suggests that judges try to make law.
the judges could put in the word.
No. Oh, judges can?
Yes, I have serious authorities that have done so. All over the world.
Judges can
Today, the law has reached a stage
Do you
where
know?
judges
I don't want to discuss law.
can in for a
All right,
word.
let me tell you. No. Let me tell you something. You know the Muhammad Ali case.
Yeah.
And the Muhammad Ali case.
Muhammad Ali, that's
Yeah,
union,
forget the name.
trade
All right.
union matter or something.
When
Oh yes,
it
when
said,
Parliament passed the thing and
when
overtake
it
it.
says
That's
it is a wrong thing to put in a word if it is not there. The Constitution makes a simple question, please. It says a majority of the elected members of the National Assembly.
That's what
we
it says.
we took hold on.
Yes.
We took literally elected members of the National Assembly as 65.
And divide
We
it
took
by
that,
two.
right? But yet we wouldn't take literally the meaning of majority.
No, well, here you asked me what is the opinion
point
of the
at-
CCG,
Yeah.
but you didn't ask me. My opinion is lawyers who went there were not fully equipped, and so on.
So why didn't you go?
Well, it's just because the Chief Justice made a. I think that's a erroneous decision to exclude me from the thing, and I have a constitutional motion on that. Right.
So
Here-
that
here
this,
was-
hold on.
No, let me get this point in.
Yeah,
on,
go on.
That there is the argument is the question was asked, for instance, why 33 can form a government and 33 cannot remove a government, and there was the lawyers didn't know what to answer at all. Apparently,
But
They
you
were
would have
shocked.
known.
No, you see, 33 forms a government. It's not the 33 forms the government. It's the thousands of electors who voted, and then each of them becomes a seat.
No. We don't want to. We don't want to go there. What I was trying to get you.
So when one man cross over, he never got no constituency anymore. Why should you?
What I was
right?
trying to get you to say, because you seem afraid to criticize the CCJ for its delay.
No, I cannot criticize the CCJ like that. I can, as I said, I appear before the CCJ, AIC Battery,
No,
the other
but
one and
it
so on
but
and so
doesn't
forth.
matter.
And
That
I don't think I am very much impressed. However, I can say that.
What kind of
Yes.
language is that?
Yes.
No, the point I was trying to make, Sapphier, is that there are about 5 issues for 5 judges to make.
Yes.
Because what I think, I think the people on the bench are sincere.
Yes.
They probably lack courage. And they do not appreciate the seriousness of the matter that they're considering.
They appreciate the seriousness, and that's why they're out of caution. Look,
So-
listen to this one. Article 10, Statute of International Court of Justice.
What we're going to now,
No, I'm showing something.
Mr.
It says
Sapphier, hold
those
on.
candidates who obtain an absolute majority of votes shall, in the General Assembly and the Security Council, shall be appointed judges in the court. So they have used the word absolute majority in the International Court of Justice, Article 10.
So because they use it, everybody must use
No,
it?
not because they use
I'm
it.
asking you.
No, because
I'm asking you.
No, they will have an interpretation of absolute majority.
Does our Constitution, the section we're talking about, use the word absolute?
Well, the court has to
No,
decide.
I'm asking you the question,
no,
man.
No, it doesn't. But here, the court has to decide. This is what the CCJ will have to decide now. Whether they would find sufficient grounds and legal arguments and precedents to use judicial activism and infer the word absolute. That is the decision they can't make, and then it'll take the next 2-3 months to do it. And
But
right?
you're suggesting they're not very competent.
No, because I don't think that the cases were properly presented. That's how I think.
By whom?
By lawyers who went there.
So you think all those senior counsels that were from
Not all of them,
Basil
but-
Williams, you had about 7 senior counsels in this matter.
I 7 senior councils from where?
Senior counsel in this
Not
matter.
from Guyana. Guyana senior
It does
councils-
not matter.
Guyana senior councils are political appointments.
Well,
That's
that's
political appointment. So forget that.
no, but they were, except for Basil Williams. Well, you had Boston. There are 2
No,
Guyanese
but
senior
I don't
counsels.
think Boston would be angry if I say that Boston don't have much experience in constitutional areas. Look, I must have done 100 cases more than Boston ever did on constitutional law.
More than Boston ever did.
Yes.
So what does that prove?
Yeah, here you have to have like legal profession. You just come out from law school. is the experience you developed over the years in the thing. That is what that.
So
makes a
you
difference.
don't have any respect. You don't think Boston did a good job. You don't think Basil Williams did a good job. What do you think of the Grenadian, the Grenadian Senior Counsel, Queen's Counsel?
I know that the guy from Tobago, one of them appeared for somebody, and I know him. He couldn't answer some very simple questions from what I listened, right? But I didn't get to follow all the arguments.
So
with
what did you think of the
Grenadian.
two senior counsel who appeared for JCOM at the matter on the matter?
I don't think that they were prepared fully for arguing that thing. Inexperienced.
But Sapphier, you don't
Yes,
seem to have a lot of respect for any of the senior counsel in the region.
Well, here the amount of look the work I have done in Constitution in the Caribbean and elsewhere, I don't think any lawyer probably in Ghana, except Mr. Rex McKee, right? That's better than me give him a chance.
Well, Mr. Rex McKay
but
did
his
appear.
age and so.
Mr. Sapphier, Mr. Rex McKay did appear in this case.
Yes, at initial stages and so on.
He
so
was not.
he
He was an attorney on record throughout the process.
Yeah, but he didn't argue. He didn't do any
But
arguments and so. But except for
you would
him, I don't
expect that
think
he
he
would
had
have
the
helped to
experience
prepare
like
the
me.
brief.
Maybe he has, but there are several other things could have been used.
Well, tell us
For
one of
instance,
the,
this same article should have been quoted.
what does
and
that
to
thing?
show how it is used, how absolute is used.
Mr. Sapphier,
But
why
then-
would you go to? Why? So you're ignoring your own constitution?
But that's only for literal interpretation, man. You
I-
have to read all the principles of
What are you
the
talking?
look, and each principle of interpretation, you have to address the court on it and to show which should be used and which should not be used.
Okay, so you cherry pick, they call it. If this one suits your purpose, you argue for this. If that one suits your purpose, you argue this.
You tell me why literal interpretation only must be used to interpret the Constitution?
I didn't say that.
Well, all right. So then you can't just
But
ask what is historically
no.
Literal interpretation is not used in
Mr.
this
Sapphier, you know,
circumstance.
I get concerned when people come on this program and
Yes.
try to fool. Persons.
I'm telling you that the
You
law-
come here,
Yeah.
you claim to be such a good lawyer,
Yes.
and you say that judges can insert words into a constitution.
Judicial activism, and in fact, I believe I have an article here.
Oh Lord, not again.
in which they have done it. Particularly the United
do-
States.
do- no, but do you know
Look
you-
at the U.S. Cases in judicial
You-
activism.
you do-
Look, go and research judicial
Oh, Lord.
activism.
You're
United
easy, you know.
States
You're not
cases.
easy, you know.
And see how they did it.
No. You don't only use such. You only insert words to try to bring some meaning if there is lack of clarity. If there is clarity in legislation, look, the legislation may have been badly framed,
Yes.
may have been badly worded, but if it is capable of a definition and understanding, you have to follow it.
Yeah, but-
You have to go with what Parliament. Who makes the law of a
All right.
country? Who makes the law of a country?
All right, here, Parliament.
Answer my question.
Let's go to Parliament. You have to go what was the intention of Parliament, not only what Parliament expressed.
You know,
Or if the intention of Parliament at that time and the
Tell me something, tell me
Travaux
something.
Probatoire or the background of it show
Tell me
that
something.
they had intended to be an absolute majority. Here, I'm not on either side, but that would have been my argument to put in the word absolute. Because that would have, look,
Mr.
156,
Mr.
156. The intention of 156 was a man should not cross the floor. But it's so badly written. It is so badly written. It
you
says,
see, you're jumping around.
no, it is related to what we're arguing.
What?
The 156 is saying that the man must write a letter to the speaker, and then
It says that, doesn't
yes, it says that.
it? And you're saying that that's not what they meant.
That is not the intention.
How do you know what the intention was?
Because at the discussion at the time, it was that it could not
Which
cross the floor.
discussion,
The time
please?
when they bring that article.
No,
in.
sir. The question of the crossing of the floor came several years later as an agreement between Corbyn and Jagbio. You recall that?
Yes.
Good. So the point, tell me something. If legislation were to say 10, and you thought and a judge thinks they meant 12, how should it be interpreted? As 10 or 12?
They have written 10.
They have written 10.
10.
It's in the law. It passed in the law. It's assented to as 10.
Yes.
And you think, judge,
and this 10 was written in error.
how would you know that it's written in error?
Well, you have to examine all the circumstances and then come to an interpretation of that.
Yes. No,
Right.
no. All the circumstances show it's 10.
Including the background, the intention, the effect, the consequence,
All
whether
right,
it
okay.
makes sense,
You
all of that. All of that is interpreted.
So we get back to this. Because, listen, everybody wants to know.
Yes.
When is this decision coming from the CCJ? Do you think it's reasonable for them to have taken 3 weeks?
Well, here, I'm not going to answer that question, but I'm going to introduce this new idea that I.
No,
right?
please. No. I am controlling this program, not you.
3 weeks?
Yes, do you think that's enough?
They said they will do it in 3 weeks. Is that
No, they
correct?
didn't say that.
No, I don't think 3 weeks is enough.
So how much time you think you
But I
should give
think
them?
here, another reason why the
How much
Caribbean,
time? Answer my question, man. How much time you think?
like 6 weeks.
6 weeks.
Yeah.
And how long they're supposed to hold? What's the period for holding elections under the Constitution?
3 months after the.
Yes.
Right.
And 6 weeks is how many days?
Well, 42.
42 days. That's close to half. And the CCJ sits on a decision for that time.
Yeah.
Do you know? You're quoting all courts
Right.
is all over the place. Do you know courts have ruled on significant cases overnight,
Yeah.
within a day?
All right. What
You
is-
know that, don't you?
All right. What is open for us to do then? File a constitutional motion that is within reasonable time, and order them to do it.
And which court you go to?
Go to the low court here.
And the low court will order the highest court?
I have brought case against the Court
No,
of
no, no,
Appeal
no, no,
in
no,
Guyana,
no, no, no.
a constitutional
I'm
motion
asking
against
you.
Court
I'm
of
asking
Appeal.
you. I'm asking you.
I am saying that the court has
You think-
jurisdiction under Article 144.8 to say that this court on reasonable delay.
144.8. You sure you're quoting the right
144.
day? You sure you're quoting
I'm
the right
sure,
day?
I'm sure.
No, I don't think
It's
so.
144. Now 144.
No, so
8 is criminal.
you think they have another 3 weeks to give their decision, and you think that would be reasonable?
There are other factors why I'm thinking so, right?
Uh-huh.
Caribbean do not have the resources for research as well, particularly Guyana. It doesn't
This
have
case
the
is
materials.
outside of Guyana part, no?
Right, and those judges themselves would like to do a meticulous job, and I think that is why they are taking such a long time. But you have to come to my point.
Mm-hmm.
How you try to evade it, that I am saying, and my press release which was not published, I am saying that the International Court may not be the final arbiter in relation to the
The what?
no case
The what? The Caribbean Court is not the final arbiter?
yes.
Where you get it from?
I am reading now from International Court of Justice,
So,
United Nations.
so you are saying that the highest court for us is the...
No, I am saying that this matter can be
That's an international court.
right. It can be reformed. Look, the ICJ Rule 65.
You were saying...
The court. Here,
I want to get this clear. No, I want to get
yeah,
this clear.
Yes.
You
I'm
as a-
saying when the CCJ
Hold on,
done right.
hold on.
Yeah.
You as an officer of the court
Yes.
are saying
Uh,
that the ruling by the CCJ is not the final ruling on this matter.
may not be the final ruling.
And you're going to go where?
A court may give this is the International Court of Justice in
But please
United
don't
Nations.
read a section and then ignore the rest.
The rest is there. The court may give an advisory opinion on any legal question at the request of whatever body may be authorized in accordance with the Charter and United Nations to make such a request.
All right. You've
Now,
answered it.
I hear
Hold
what
on,
it says. Questions upon which the advisory opinion of the court is asked shall be laid before the court by means of written request containing the exact statement of the question upon which the opinion required and accompanied by all the documents.
Mr. Sapphier Hussein, you realize you're talking there about an international court,
Yes.
and we're talking here about a domestic court, and it's a domestic issue. It's a matter involving your constitution. The international court doesn't get involved in dealing with people's constitution, does it? No, I'm asking you.
No,
do you know of any instance where it's done? It is so unthinkable that
right.
it's hard that you would mention it.
You think that this matter under that article, you can't ask the ICJ for an advisory opinion on it?
I am absolutely convinced that you cannot.
You
ask
cannot.
them. They would decline jurisdiction, to use your
No, I'm
famous.
saying they have jurisdiction.
All right, okay.
All right, that gets me to another point that I want to talk about. I'd sent some correspondence to Mr. President Donald Trump, and one of it was that President Trump has brought a new consciousness to the refugee problem of the world, because the Convention on Refugee 1951 is written and only refer to the receiving state, but not to the state of origin. You read the entire convention.
Mm-hmm.
And
so you wrote him, what did he write back?
No, I'll tell you the point.
No, because time is running,
and
I'm saying, I want to ask you.
I'm saying that the Convention on Refugee.
Okay, we'll come back on that. But let me ask you this: you're a political party. You're a political party leader. Is your party preparing for elections?
Well, we have intention to contest the election, but we are awaiting the decision and then the environment and so on. See how it goes.
Is your party putting together its list of candidates?
No, we haven't put list of candidates before now at this stage. We'll put the list of candidates during the period when it is required. That is what we do.
So, how effective has been your executive between elections?
Well,
do you have an executive that meets regularly?
No, we don't really meet regularly, but we meet occasionally and so on, but on major points and so forth.
Would your key people want to be named on this program as to who they are?
Well, maybe on another program. I will get,
but this is plain talk.
Yes, no, I can't name them now because there's so much discrimination out there and victimization.
But look, you've been calling Jaipal Sharma name whole night. I mean,
no, I said Jaipal. He appears in the television and so on, and he makes statements and so forth, and he makes constitutional statements.
Mm-hmm.
That's what I said.
Mm-hmm. Well, yeah, he has strong positions on whether there was a no confidence or a confidence motion.
That opinion, which is an illegalistic kind of argument and so on and so forth. Right, that point.
I know. I've heard a lot of that argument.
Yes, and I think it's Sri Ram said if there's a negative, there's also a positive and so on. One of the Trinidadian cases.
Okay. So would you be contesting elections if they?
No. What is the most important thing that we cannot avoid having a discussion on is that Guyana has now reached a different status, right? With the present, Guyana has become probably one of the richest country in the world, and as such, there is.
You've heard about the resource course, haven't you?
That is superstition.
That's superstition?
Yeah, I think so.
You know what the resource course is?
Yeah, that. Well, as I see it, you have to organize, and you have to have a government that can manage the present, the affair of the country at this time.
All right, we're getting the signal.
And competent, capable, and experienced and learned persons who can do it.
Mr. Sapphier Hussein,
Yes,
thank you very much for appearing on Play Talk. Operators and viewers, thank you. Good night. See you next week.
Okay, thank you very much, and I trust that I have been able to assist the